Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I'm your host, Sophia Morales, and in today's episode, we're diving into the essential topic for creators navigating the world of fashion, protecting creativity, why IP law matters in fashion, art, and design. If you're an entrepreneur, designer, or creator looking to safeguard your brand and designs, this episode is packed with valuable insights you will not want to miss. So let's jump right in. I'm so happy to have you back with us today, Vincent.
Hey, Sophia, it's great to work with you again.
So fill us in. I know you've worked with a lot of inventors and creators. What makes IP law especially important for those in fashion, art, and design?
Well, fashion is a unique thing, and they're talking about changing the laws for copyright to help clothing get protected better. But it, mostly, as far as protecting a certain type of clothing, there has to be some sort of utility to it. Maybe you can do like the way it fits, or like maybe the bra that holds, your breast together more, or something that it does something more than just the look of it. The look usually gets copied, right? And you
Right.
watch the Emmys or the Oscars, and Oscar de la Renta and Yves Saint Laurent. They all walk in front of the red carpet, on the red carpet in front of the cameras, and then the next day Kmart copies them all. And
I was going to say Temu.
yeah, they just come out and just copy them. And
Yeah.
and what happens, like when you go to the big cities where they're giving you knockoff purses and knockoff clothes, and they're actually using the trademark of those big designers. So really the design isn't protected, but the label is, and that's through trademark. And you think about it, when you see a knockoff purse with the trademark of one of these big labels, so that's both a civil and a criminal, offense, because
Wow.
you're literally, you could literally end up in jail for doing that. But I mean, you go in any big city, New York City, up on right by the South Street Seaport, and and they're selling them on the street, all these designer bags. So really, the trademark is what protects them. It's not so much the look, unless you could argue that that maybe it's a design, it has some sort of utility, or a specific design, and you did a design patent with it. But it would be prohibitively expensive to, every time you came up with a new design, to try to get a patent on it. It would just be too expensive for them to do it. So what I talked to some of the big fashion industry people, and one was New Era Cap, and they said, look, we'll come up with a new cap, and as fast as we do it, 10 people are copying it. But we're so fast to the market that by the time they start copying our cougar hat, we're already with the puma or the lion hat. We're just pumping it out faster than the next guy, and we can just get it out. And by the time we're copied, we've kind of run the gamut as far as how much people like it. And I guess there's certain momentum you have when you start selling a certain style, and whether or not you're selling that style to to the individuals on the street, whether it's cool when it first comes out, but after a while it gets old. And so by the time it's old, they're hoping that they're on to the next iteration, the next best thing.
So speed in the fashion industry is a form of protection in and of itself.
Yeah, absolutely.
And then like the trademark aspect of it is where you can really get down with like a cease and desist and make a difference, as opposed to, oh well, that's my design.
Yeah, that label, and I'm sure I said this in other episodes, is your trademark. It's just like a brand on the cow, and it's my cow. Don't get it mixed up with your cow, and that's where branding, originally started. But you're marketing your product, and nobody else can put that product on there, and you could use it as a sword to stop others from doing it. So somebody's actually using your trademark and counterfeiting goods. That's your best protection in the fashion industry.
That now makes sense to me, because I've always wondered why, with the Gucci or Chanel purses or whatever, they've got their brand like all over the fabric. Now it makes sense to me.
Yeah, so nobody else. Yeah, like if you see the VL Louis Vuitton, I was joking around and say it's the Vinny LoTempio brand, and but because my initials. But yeah, but that's exactly it, and that's why that suitcase or that briefcase or that purse is covered with the label is that nobody can make that. But if it's just the design of a purse and the look of a purse, it's kind of hard to save that. There is something known as trade dress, and trade dress is like 1964 Coca-Cola register the trademark for the shape of the bottle, the look of it.
Right.
And
Yeah.
Christian Louboutin, the bottom of their shoes are red. Nobody else can make a shoe red. You can make any other color, but you can't make it red because it's so distinctive and so famous, and everybody recognizes that Christian Louboutins have red bottom shoes. That
Ah,
they're the only ones that are allowed to do that. So even though it's not strictly a label, it's the look of it. It's the trade dress. So it is possible to get a certain iconic shape like the Coca-Cola bottle or an iconic color like the brown for the UPS truck, that you can say the look of it. Like if you wanted to start a parcel service and start painting your trucks a brown, the same color as UPS, that would be a problem. They'd be able to stop you as that's their trademark, their trade dress.
excellent. So I know we mentioned that there are companies out there who are deliberately fast paced in releasing their stuff and riding those trends. How do designers effectively protect their work in an industry where everything evolves so rapidly? I mean, we talked about the trademark being important, but are there other methods that they can use?
Well, that's like I said, for just fashion, and that's a big problem in the industry. People could just copy it. It's just another way a shirt or a collar is done. And I was watching the golf tournament the other day, and or the and basketball playoffs, one of them, and one of the women announcers had these big bell bottoms on. I'm like, that was those were popular in the '70s. It's like what's old again is new again. So yeah, I think just generally speaking, if you talk about fashion itself, the designs are very difficult to protect unless there is some sort of utility of how it holds together. Or, I actually did a patent where a woman had an exercise pants with like a rubber band attached to it somehow, where you could stretch it and exercise. And
Oh,
so, but it has to have to have some sort of utility where it, like a bulletproof vest where it's going to stop bullets from coming, like the Kevlar or waterproof, agent. But it can't just be looks alone.
gotcha. So, speaking of looks alone, when it comes to things like visual art, what are the key differences between a copyright and a trademark protection when you're dealing with a fine artist, for example?
One of my questions on my trademark questionnaire is who made your design? Who was the artist that drew it? And did you have a contract with that artist? So if it can be considered a work of art, like a visual piece of art, it could have both copyright and trademark protection. And when you create anything and you put it in a tangible form, like a whether it's a picture on your phone that you took, a drawing that you make, or a painting, you instantly have what's known as a common law right in that copyright. Now, if you hire somebody to make that picture to use as your logo, like the Nike swoosh, for example, that person owns that the rights to the copyright of that, to the extent that they made it and they sold it to you, but they still own the rights. They just sold you the actual drawing. It's like if I make a painting and I sell you the painting, you own the painting, but you don't own the copyright to it, where you can sell pictures of it and you could use it. You just own that particular painting, unless you have a written agreement, and it has to be a written agreement, and it's called a work for hire agreement. So
Yes.
you need to have a work for hire agreement with that artist that basically says, I, the commissioner of this piece of art, paid you an X number of dollars for all the rights associated with this, including the actual mark itself or the actual painting itself. So without a written contract, you don't own the rights to it. So a lot of people think, I think it was the first case a woman funded or produced an entire movie and didn't
Mm.
get anybody to sign off on the copyrights. And she was thinking that since I paid everybody to do this, I own it. She didn't even own the copyright. So that was the seminal case that started this work for hire agreement, where you have to have a written agreement that specifically transfers the rights over to the commissioner of the work. So that's a very important thing that, I often ask people, where did you get it? Did you just get it off the internet? Is it somebody else created it? Do you have a work for hire agreement? Do you have some sort of agreement where you own the rights to it? So that's very important that you make sure that that there's that work for hire agreement, and that they're willing to assign all those rights over to you.
Yeah, I could see that. That could lead to a lot of complexity down the road when you start like trying to sell prints of something or
Yeah, exactly.
Yeah.
And if the woman who did and she was just a girl at the time, the Nike swoosh, and she was like in high school, and she got paid $35 or something, maybe $65, and she bought her prom dress with the money, and she created the Nike swoosh. So could you imagine, when they're selling millions of dollars worth of it, they didn't have a work for hire agreement, and she says, no, I have the rights to it. You don't,
Yeah.
but
I want a nickel
I
for
don't know
every
how
tennis
much
shoe you sold.
they ever, I know, I don't know if they ever did that or gave her any money, but I did hear, like, on the anniversary of the swoosh, they gave her a diamond encrusted swoosh as a gift.
Oh, that was nice of
But I
them.
don't know if they paid her any money or anything else, but yeah, that was an interesting story.
Indeed. So, when you're dealing with an independent creator or a very small design studio, what do you recommend they start with when they're looking to protect their IP, especially on like the shoestring budget that most startups have?
Yeah, and there's so many different ways to get these designs, and you just have to read the fine print. And so many of us, when we're on the internet and they ask you to check the button that you read everything, nobody reads it, right? Who reads all that stuff? I don't read it. I'm an attorney. But for something like this, you better make sure that they're going to sign this work for hire agreement. And I can create a simple work for hire agreement in 2 minutes, from a template, and make sure that you're protected. So, I mean, that's the key. There's got to, even if you want to read the entire thing, read the part about who owns the intellectual property, who owns the copyright, and make sure that has been transferred over to you. The other thing that you have to be careful of is that they didn't just go online and just take it from somebody else, and they're just basically stealing it. And so one of the things that I'd want to make sure was in that contract is that they guarantee or warranty that they created this and they didn't get it off the internet, or they didn't get it from somebody else, and it's not going to infringe on somebody else's. And if you do get sued, that there's a clause in there that says that they're going to stand up for it, and they're going to, it's called indemnification. They're going to indemnify you, and they're going to stand in your shoes and defend it. And again, if you're on a string budget and you're using a fly by night type of arrangement, and they don't have any money to defend it, I don't know how strong that is. A lot of times they say you can't get blood from a stone.
Yeah.
But those are some of the things that you have to be aware of. And when people come to me to file a trademark or a copyright, I always say, look, it's more than me just filling out the form. Anybody can fill out the form. A lot of people can screw it up, but I've been doing this for 25 years. I want to make sure that these type of problems are checked off. The boxes are checked off before we file it, to make sure that down the road this isn't going to be a problem. It's always easy to pull the bandage off. Look, let's not use this guy. I know you're in love with this drawing or whatever, but we can't be sure that he actually owns it, and we can't be sure that if they don't want to sign the work for a hire agreement, that it's going to come back to bite you. So it's always easier to pull the bandage off now, come up with a new design, and make sure all our our I's are dotted and our T's are crossed.
Okay. Let me ask you something, because I think there's a misapprehension out there amongst entrepreneurs that royalty-free means free for me to use. Is that a truth?
Well, I guess it depends if it's in the public domain. And then there's a lot of people say you could use my work if you give me credit for it. So there's some sort of language there that it's called attribution language, where you attribute the copyright or the trademark of that artist or that company that has it, that says go ahead and use it for royalty free, but they're still going to want some attributions. But yeah, that's definitely a problem. People think if it's up on the internet, I can copy and paste it and put it on my website. And I'm constantly getting letters from like Getty and other types of people like Getty saying, look, you pay us $2,000 for using that picture of the frying pan in your ad. That was our picture. That's our image that we own. And these big companies like Getty, they have these spiders that are constantly looking for it. And they can find, they have what's called the Wayback Machine. I don't know if you heard of that.
Yes.
So they
Uh-huh.
can go and find something that you put up 20 years ago and it still can come back to haunt you. Now, you might say, well, 20 years ago, isn't there a statute of limitations? So
Yeah, isn't there?
so the statute of limitations is basically from the time that you knew about it or should have known about it. So they
Oh.
could extend the time because they just found it now. And I always say, look, if you have to come to me and ask me, is this a problem? You probably know the answer. Is this too close to the Coca-Cola bottle? You already know the answer to it. And then I add, the old adage, don't poke the bear, right? Why poke the bear? Let's stay away from the bear. Let's stay away from these types of problems. Make sure we have a nice clearance on whatever we're going to use, that it is royalty free, that it is in the public domain, and that somebody's not going to come back after us later suing us after we have 75,000 labels on our products all over the country. We have to go and take all those labels off. It's a lot easier right now to change the name or change the mark or not use this piece of art than take off 75,000 labels off cases of apple juice.
Yeah, and it'll be a lot faster to do it now than it will be once
No,
you have 75,000
no,
units out there.
the cost, the time, the money, starting over, all the goodwill that you've had already because you've advertised it. It just, even though you're starting from scratch now is going to be way easier than 3 years from now after you've done all that other stuff. You have signs on the windows, on the doors, you have websites, and you got to change everything. Maybe there's federal regulations as to having a license to do something, and then you have to go and change all your licenses because the names are all wrong on it, whether it's like selling a car or something like that. They have all these regulations that you have to deal with, banking rules. So yeah, pulling the bandage is better than getting your arm amputated.
Indeed. So, to kind of tie it up with a bow, if you're talking to a young creative who's entering one of these industries today, whether it's design, art, or fashion, or what it is, what is your largest piece of legal advice when it comes to safeguarding your ideas and your identity when you go out into the marketplace?
I think the first thing you do is whatever you're going to use, like your name or a portrait or a painting or something that you got off the internet, is do a good search and be sure from the beginning that this type of thing isn't owned by somebody else, or this name or this brand or this logo isn't being used by somebody else. I'm just doing a trademark search before I came on here, and and there was a couple of letters and there was a speedometer on it. And then I did a search using the design code for speedometers, and there's a ton of speedometers out there used to, in the motor industry, or, you're used to show speed. But your speedometer is different than somebody else's speedometer. I always use it like for the Buffalo Bills, right? Their Buffalo they have the trademark on, but they don't own all Buffaloes. So you can make your own Buffalo that's different enough from theirs that isn't confusingly similar. That's the terms of art for trademark, is confusingly similar. And I always ask the question, again, if you have to ask the question, does this look too much like the Coca-Cola bottle? Then it probably is. If you got to ask those types of questions, then you already know the answers for it. So my advice is, don't poke the bear. Try to be as unique and original as you can, and do your due diligence with a search.
All right. Well, thank you for all of that information. That gives us a lot to work with, I think. And thank you for joining us today on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. Please visit lotempiolaw.com in order to get in contact with Vincent and the team, and be sure to like, subscribe, and review so that others can find this important information as well.
Thank you, Sophia.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.